Good evening, everyone. Justice Deshmukh, Mr. Divitri, Mr. Thakkar, Mr. Dhond, Ms. Sachdeva, Mr. Desai, members of the bar, ladies and gentlemen. Welcome to today's event, which is an event which is jointly being hosted by the Bombay Bar Association and the Mumbai Center for International Arbitration. The topic why you all are all here today is to hear from these experts who are sitting on the dais about life on both sides of the arbitration table. I think that anyone who has been practicing for a number of years has realized that there has been a marked growth and traction in alternate dispute redressal systems, whether it be arbitration, whether it be mediation. You've all heard now judges, the Solicitor General most recently also pointing out how lawyers need to devote time into focusing on these spheres to lessen the burden in the courts. One of the most important ways, aside from our ad hoc arbitration, is institutional arbitration, such as what MCIA provides. And as long as we as advocates continue to treat arbitration as a 5 to 7 on weekdays and a half day or a full day session on a Saturday, we're not doing it justice. And I'm sure most of you all will agree, and I know I've seen it, that there has been a growing trend of lawyers who are actually gravitating to practicing only in arbitrations and doing arbitrations the entire day. I do believe that slowly and gradually there will be a shift where more and more lawyers will have to elect as to what they want to do, as more arbitrators also are now refusing to say, no, I'm not only going to sit in the evenings. We will sit the entire day and make use of the time that we actually have. So without much further ado, let's hear from the experts. But before that, could I please request our President to give a small memento as a token of our thanks and appreciation to Justice Deshmukh for taking time out from her extremely busy day to come and share her thoughts with us. Could I also request Mr. Thakkar to please give a floral bouquet and gift to Mr. Divitri? And really special thanks to Mr. Divitri, because as most of you all would have seen, actually it was Dr. Sathe who was supposed to come and speak today. But last minute, considering his position, he had to back out because of some urgent professional commitments. And Mr. Divitri most graciously has agreed to come and speak to you all today. So a very, very special round of thanks to Mr. Divitri. Yes, sorry. Then if we could also thank our own Vice President, Mr. Dhond. And if Mr. Thakkar could also please give a memento to Ms. Sachdeva from MCIA. And also to Mr. Desai. Yes. And Mr. Thakkar corrects me where I go wrong. So I also forgot to say that the Chartered Institute of Arbitrators, CIAB, is also jointly hosting today. So with that, could I request Justice Deshmukh to come and say her?
Senior Advocate Mr. Divitri, Mr. Thakkar, Mr. Dhond, Mr. Engineer, I'm just looking from here to here, Mr. Engineer, Ms. Sachdeva, Ms. Vyapak Desai, the committee members of Bombay Bar Association, and I would say fellow arbitrators, because there will be many in this crowd who would be arbitrators in their own right, and friends. Sitting on this assignment of Section 34 as of now, I have realized the significant development of arbitration when I realized that the body of law which has been developed on an enactment which is only of 87 sections. 90% of it goes to the ingenuity of the advocates who interpret it in such an amazing way that it has developed exponentially. Along with that, there is also proportionate growth of advocates, practitioners who are acting as arbitrators. And I feel that though they have moved from the conventional court litigation, their role in the justice delivery system needs to be recognized and appreciated. Considering the complex arbitration issues which arise in each and every case, of course there is a need for trained arbitrators, for institutionalized arbitration, wherein institutions such as MCIA and CIRB come in and they train arbitrators. Need for trained arbitrators, I would accept, it is there. But whether there should be a separation of roles between a counsel and an arbitrator, I am not so convinced about it. For this reason, that when practitioners are appointed as arbitrators, they go from an advocate to an arbitrator and an arbitrator returns back to practice. So when they have this dual role, when they are arguing in courts or trying to protect an award, or when they are sitting as arbitrators and delivering a judgment and an award, they know exactly where the arbitration table will crack in the court. And therefore, considering that dual role, I do not think that there should be any separation of roles where counsel should appear only as counsels, whether before arbitrators or in the courts, and the arbitrator should be a separate cadre in Nismet. But at the same time, considering that India is now emerging as a preferred destination for arbitration, there is also a need for a shift in the arbitration ecosystem, because it will not work that from 11 to 5 I am going to be in the court and thereafter after 6 I am going to go for arbitration. Or I want to be in the court also, I want to be in arbitration also. You as lawyers who want to be arbitrators or want to appear in arbitration proceedings need to work out some mechanism where you not compromise on your court litigation, but at the same time you ensure that sufficient time is being dedicated for arbitration. And in fact, today's topic for discussion, crossing the floor, life on both sides of arbitration, is assumed significance in that respect, because there has to be a balance which is required to be achieved as arbitrators, as counsels. When you transition from a practitioner to an arbitrator, there is a shift in the perspective. From the art of argument, you move on to the art of a judgment. From arguing and arguing and arguing, you go to listening and listening and listening. From persuasion, you go to patience. And I hope that when that patience as arbitrator comes into you, when you come before the court, that patience shows, which is missing. As arbitrator, what happens is, there's a terrifying weight of silence, because you have to silence your inherent advocacy. That needs to be mastered. You need to be impartial, evaluate evidence objectively, and that is where the training as arbitrator is required to be given. Not as far as the law is concerned, because all of you are very well versed in law, but the manner of evaluating evidence objectively, impartiality, is some of the grounds on which training is required. It is somewhat like when you are suddenly elevated on the bench from the bar, you tend to argue more than the lawyers. This is what happens when you do in arbitration. You tend to argue more. You think as if you are a lawyer. And then when you again come back into practice, you carry that along with you. Fortunately for judges, we are not allowed to come back. Others would have done the same thing. So therefore, this key change in perspective, which is a profound migration, that needs to be mastered. And for the purpose of mastering the same, it is very necessary for a training. which I think CIR deals in that. So that training is very, very important. So I was told politely not to speak for more than 15 minutes. No, not to speak for less than 15 minutes, which should be read as not to speak for more than 15 minutes. And we have very distinguished speakers over here, which will have a very in-depth analysis of what the two sides of an arbitration means and how do you cross over from one side to the other. But I will just conclude it with one thought, that irrespective of what side of the table that we are sitting, chairs might change, designations might change, responsibilities definitely will change, but our commitment to fairness, integrity and justice is something which remains constant and should remain constant. Thank you so much.
Thank you so much, Justice Deshmukh. I particularly like the ending of your speech. Could I now request Mr. Divitri? Okay, very well. Very well.
Good evening, everybody, and welcome to this Bombay Bar Association, MCIA and CIAB India event. Today's is one of that event which touches almost every one of us in this room. The topic is such: you're changing the table. Are you a counsel or are you an arbitrator? For most of us who are in this space, I would say this is a question that we grapple every day. We are witnessing, we are doing a cross-examination of a witness at 11 a.m. in the morning, and we may be writing an award in the evening. But the question that remains to be answered is that does sitting an arbitrator make you a sharper advocate? Does advocacy make you a better grounded arbitrator? What are the ethical considerations? Where do you change the line? I have a great panel with me today. Now, reconstitution of an arbitral tribunal is very common. We have it why? Because parties want to seek an adjournment, they want to delay. But today there is zero adjournment, there is zero delay, but we still have a reconstituted tribunal. So we're very thankful to Freddie, as we all lovingly call him, to have stepped in and not let us have a delay in this event. Let me start with you, Freddie, on this then. Tell me that in your experience as an counsel and as an arbitrator as well, you've seen the practice grow. Do you think the sort of arbitrators who would get appointed earlier on, which usually would be retired judges, has moved on to counsels? Or does the practice more or less remain the same? It's only maybe on the face of it a little bit, we see a covering of it to say that the counsels are being appointed.
I don't know, but I think this is the first time that a 12th man has been asked to open the innings.
And who better than you?
But to go back to your question, I think when we started in the 1970s and 1980s, arbitration was a by-the-way kind of proceeding. It was usually in the evening from, in those days, 4:45, court got over, so you did it from, say, 5 to 7 or 5 to 6. You did it on a Saturday when you were free. There has been a sea change, to my mind, in that respect, in the sense that today arbitration is virtually like a court proceeding. Even in those days, there were arbitrators who were largely retired judges from various high courts. The change I see in the last few years has been the influx or the appointment of more and more advocates as arbitrators. And personally, I think it has been a step in the right direction. And I mean, I must say this, I see a lot of young faces here. I have known young advocates being appointed as arbitrators, people with, say, 7 years standing, 10 years standing. And they do a fantastic job in the sense that they are very keen to dispose of. And at least the ones that I know of, there is a tendency to think that if a senior appears before a relative junior, I'm not talking of people who are in the same chamber. I mean, that's a separate topic entirely. But say a senior appears before Mr. Thakkar, appears before, I would have said me, but I'm not yet, I'm not as young as I used to be. But there is a tendency to think. But I find that young advocates control their proceedings extremely well. And they are very organized and very disciplined in what they do. And having said that, I think much of the credit in the last few years should, I think, go to two judges who handle the Section 11, Justice Kathawala, who as a matter of routine would not appoint retired judges but appointed young advocates, and Justice, I think to some extent, Justice Gautam Patel, who also followed the same course. So I think there has been a sea change in the manner of appointment of judges, and I don't know, maybe the time has now come to think, we always thought of arbitration as you choose your own arbitrator and therefore party autonomy, etc., etc. Today, in very few cases do you choose your own arbitrator. Today it's the judge who decides who the arbitrator will be. So the whole concept, the whole basis of an arbitration may perhaps need to undergo a change.
No, I agree. I mean, MCI has been involved in almost appointment of now more than 190 arbitrators. So, and I can tell you that almost 80% of our arbitrator appointments have been non-judges, non-retired judges. So we're trying to make our own small wish. I mean, some of you present here have sat as an arbitrator with MCIA as well. And that's what we are working towards, to make sure we have a larger pool of arbitrators. But let me turn to you, Mr. Dond, who's also the Vice President of the Bombay Bar Association. Many thanks for accepting this. We are well aware, all of us, that you have built a great reputation as a courtroom advocate. You do, I would say, sparingly sit as an arbitrator. But as and when you do you think your advocate's instinct of persuasion, rhetoric, come into the way, work against you, work in favor of you? What has your experience been?
Right. So, when I'm saying I'm speaking not just for myself, but I'm talking about a practicing lawyer. There are 2 or 3 advantages that if you are a practitioner that come when you are being an arbitrator. Number 1, if you are a trial law practitioner, if you are a trial law practitioner, then at least as far as aspects of evidence, you know, what questions will be allowed, what questions will be disallowed, cross-examination, etc., etc. There your trial background is of great assistance, because primarily we are all interlocutory or, you know, statute lawyers, but most arbitrations involve evidence. So that is where a background of some civil trials, etc., is extremely helpful if you are an arbitrator who's also done trials, because otherwise for an arbitrator, for a non-trial law experienced arbitrator to be able to assess trials as they are going on before him is something where you are at a disadvantage. That's point number 1. So if you have trial experience as a lawyer, it is certainly better. Point number 2 is, when you are a lawyer who is arguing regularly, you have a sixth sense of knowing where things are heading. So you instinctively know, is this the right direction? Is this person bluffing? Is this person not so serious? Is there a problem here? That sixth sense comes to you as an arbitrator because you are a lawyer. So that's another, it's an intangible assessment. You can't describe it, but you have a sixth sense that, look, there is a problem here. So that helps you in assessment. That, I think, these are the 2 benefits which certainly come. And when I'm saying this, I'm saying it from the point of view of somebody where you're assuming that the lawyer who is acting as an arbitrator is acting as an arbitrator with no restrictions on time. Otherwise, practicing lawyers being part-time arbitrators, according to me, is a bad idea.
I totally agree with you on that, and I think, again, representing as an institution, I can say that when we are appointing arbitrators, the first requirement that we have is that they have to conduct arbitration 10 to 5. Are we successful all the time? No, but I think the practice is definitely developing on that. You're right
but that is very important. I mean, I'm saying it, unless there is institutional oversight, it becomes a club of part-timers. It's a very happy thing. Part-time lawyers after court, part-time arbitrators after court, which is why an organization like the Mumbai Arbitration Center is very important. We need discipline. I mean, let's be very honest.
Right. You spoke about how counsels and arbitrators, is a good mix when one learns from an experience of one and then takes on the seat of the other. Vyapak, let me come to you. You wear multiple hats, let me say that. You have been a part of the MCI Council. You're also on the board of the CIAB Institute of India branch, which trains arbitrators. And now you are a counsel out of a law firm as well. So you've worn different hats, and many a times you're a counsel and an arbitrator at the same time. Tell me what Mr. Don just spoke about. Do you think there are ethical and conflict considerations when you are accepting one and the other, and how do you mentally balance those two out while you're moving between those two roles?
Sure. I think as a counsel and as an arbitrator, right, I think it's not an uncommon practice across, it is not an uncommon practice across the world and in India. So it's not unique to anyone in the field of law to act as a counsel and to act as an arbitrator. Coming to the issues of conflicts, I think the first and foremost is legal conflict, right? When I was in a law firm, obviously those legal conflicts were much more because then you have to look at it from a perspective of the firm and rest of the partners and what firm has done over a period of time. But I think the very first appointment actually for me came about where there was nothing in reference to India or India related work, right? So what happens when you, these are the advantages of an arbitration, right? That you are not constrained with any jurisdiction. So you can be an arbitrator for a, let's say, we are only looking at from a perspective, we are sitting here in Bombay Bar Association, therefore we are looking at Section 11s in Bombay Bar. But now with all the technology, with all the, issues and whatever support we require in terms of running the arbitrations, arbitrators are appointed across the globe. And forget the globe at the moment. Even a Delhi International Arbitration Center can appoint Bombay lawyers and vice versa, and MCIA does that all the time, irrespective of where the seat of the arbitration is. The counsel or the arbitrator can come from any part of the country in that sense. So I think the first and the foremost is you also need to, open up your horizons and see where will you find those kind of situations where both legal conflict and the other time conflicts or issue conflicts are less or at least can be avoided to start with. Two, I think as a counsel practicing in courts, definitely you don't have an opportunity to do both trials and high court work, right? Because if you are doing high court work, hardly you can go to a city civil court and do a full day trial because then you will conflict. Same thing, ma'am said, you can't be a judge and a counsel, you can't come back. But this is one area of practice where you can keep shifting between being a judge and being a counsel. And I think more than conflicts, I think it is actually skill building, right? We talked about patience and persuasion, and these are two different skills, right? I think the skill building that happens by wearing two different hats or playing two different roles is tremendous. And some of the soft skills, right, which gets developed over a period of time are, enormous. They are not, can be, in that sense can not be valued in terms of how your practice will go. So my sense is legal conflicts, there are ways and means to, manage it. Yes, of course, with the schedule 5 and 7, now it's even more easier to see where you are conflicted and where disclosures come into play. So it is more objective than subjective. So that takes care of your legal conflicts. In terms of time and issue conflicts and mentally how you shift between being a counsel and being an arbitrator, I think at the end of the day, of course, as a lawyer, if you have taken a view in a particular manner, as an arbitrator, it becomes that much difficult to argue it differently. But I think as lawyers, we are ingenious enough to say how facts change the law, right? So I think, of course, there are certain issues which come where your counsel practice and vis-a-vis arbitrator practice can get restricted because of dual role. But in my view, that is a very small risk and a small payback to what you get when you are, doing both. So that's how I look at the practice going.
Yes.
So, one thing I wanted Mr. Divetri's as well as Mr. Dhon's opinion on this. When I'm sitting on this assignment, I realize that the arbitration proceedings are being considered something like a pre-court proceedings litigation. Everyone comes with a mindset that after an arbitration award has been passed, the next step is the court. The whole purpose of Section 5 of the Arbitration Act is missed. There has to be a minimum judicial intervention. But this is not happening. And I see most of the practitioners arguing Section 34 as if it's a first appeal and then a second appeal. So somewhere that mindset has to be developed that an arbitration proceeding, like Mr. Desai was speaking to him, it's not even an alternate dispute resolution, it's a parallel dispute resolution. Don't try to intertwine the court litigation and an arbitration award as a next step. So there I feel some care requires to be taken, because otherwise ultimately if you are going to end up in the court, there is no purpose of arbitration proceedings and a finality to an award.
Yeah. I think that's a very important point, and I think a time has come when we must re-look at the Arbitration Act and the number of remedies provided against an award. I mean, you have you bring it under a Section 34 before a single judge, you go to a division bench under 37, you go to the Supreme Court. I mean, those kind of remedies are not even available, say, in revisional jurisdiction or in other jurisdictions. So I don't see why we are treating arbitrators as some kind of separate thing where you can adopt all these legal proceedings against arbitrations which you couldn't even do against, say, a single judge's order in many cases. You go straight to the Supreme Court, you against tribunal orders, you go straight to the Supreme Court. I think that the time has come when we must be re-looking at the number of avenues available for recourse against an arbitral award. Maybe the time has come to provide a full appeal if it's necessary. Just one appeal perhaps, and that's it. I mean, either and maybe it's maybe a full appeal. There may be a lot of amendments which are required, but I think that's a very important point, because even as an arbitrator, personally, I always feel that when you are recording evidence, for example, when you are dealing with objections, for example, I believe that an arbitral tribunal must be allowed a little more latitude and a little more informality than a court proceedings. We are not, as you said, we are not alternative, we are parallel, but parallel in the sense that we don't have the formal trappings of a court. So if an arbitrator in his wisdom allows a document to come in, I very often find that courts adopt a hyper-technical view saying it doesn't satisfy so-and-so section of the Evidence Act or so-and-so section of the whole approach, perhaps the mindset. And many people forget that the very first section of the Evidence Act says that this act shall not apply to arbitrations. Very often people forget that. So, I mean, I know we've evolved a whole system of law with Supreme Court judgments which say, no, an arbitrator must follow the law in evidence, etc. But I think judges must adopt a greater latitude that the arbitrators, as Venki, Mr. Dhon said, you have a gut instinct as to whether something is right or something is wrong as an advocate. And very often that gut instinct translates itself into some kind of an informal reasoning, which I think a judge must respect when it comes to court.
I think we've had, all of us would have many war stories discussing about it and can go on for hours onto it itself. But let's come back to the topic we're talking about on counsel and arbitrator. And Venki, if I was to come back to you on this and say that Indian advocates have a habit of advocacy in a particular way. I'm not here commenting good, right, bad, ugly, good, whatever it is, right? But there is a habit of how we present ourselves in a court.
Right.
When you are sitting as an arbitrator, do you have maybe a checklist or 3 wish list, I would say, where you say, I wish lawyers would unlearn this habit and then come in before an arbitrator to argue a matter?
Right. So, 3 or 4 things which I would like people who are arguing before an arbitral tribunal. One is that you have to, I mean, I am now discussing a tribunal in the sense which is functioning as a tribunal should. A tribunal has 1 case a day. A judge has 20, 30, 40. So please do not assume that this tribunal has read as little as the judge, because this tribunal has 20 times more time. So the first thing that all of us as lawyers, when you migrate from appearing in court to appearing in, before a tribunal, is we forget the fact that the tribunal comes with far more time at its disposal. So you need not take the same approach that you take with a court, because the burden is very, very, very different. So you have to therefore accept that there is a basic fundamental difference in the level of reading that the tribunal has come with, which takes a little time. So that's the first point, because many tribunals who have read and come wonder, why are you going on and on about this? We know this, you know, and if you tell somebody we know this, that person, unless that person accepts the fact that you know, that person is not going to accept your statement that I know it. So one very important factor is to sort of accept, or to at least assume, give the benefit of doubt to the tribunal, that the tribunal has read the pleadings and has come. That's point number 1. Point number 2 is that you should, because you are dealing with a tribunal which is taking that case from beginning to end. It's not the way we do it in court, that today I may be arguing before A, tomorrow I may be arguing before a different judge, day after tomorrow the same matter may be before a third judge. Because there is continuity, you should at least place your case with a certain structure, so that the tribunal knows this point will be followed by this point, will be followed by that point, so that if they tell you, yes, we are with you on this point, you need not labor that point, then you can move on. If you just do not give them a sense of the direction that you are taking, then it's a waste of their time, it's a waste of your time, it's a waste of the machinery of arbitration. So these are 2 things which I feel lawyers who appear before tribunals should do. And of course, lawyers who do tribunal or arbitration work all the time, they of course have a very structured way of going about doing it, which sometimes court lawyers lack, because you do not really understand that the tribunal functions on a very different time frame and a very different level of reading.
I mean, I think it's India that we see that a lot of our lawyers who are practicing in the court also end up being in the arbitration, while if you look at jurisdictions like Singapore, London or Paris, you have a sort of an arbitration bar which is very distinct from the court litigating bar itself, right? Whether it has its own advantages, disadvantages, that is of course a discussion for another day. But let's come to something which is now on the other side of the table, right? Which is, Vyapak, coming to you. Now, when you are sitting as an arbitrator, you have learned, unlearned, done certain things, right? Now, when you appear before a court as a counsel, do you think you're able to anticipate better as to what the judge wants to hear, rather than what the client wants to make sure that the judge hears?
I think it happens naturally, right? Because as I said, you are developing the skill to listen and interpret, adjudicate. Sometimes when you are sitting as an arbitrator, actually you get very impatient that this is such a great point, why the plaintiff or the respondent is not even arguing, right? You are itching towards the point that, okay, this is, you have a document, you can just point it out, otherwise I will, how I will give you this order or something, and the counsel or the, advocate would not even come close to what they should have argued, either under law or based on the facts. So I think when you are sitting as an arbitrator, you are able to obviously look at the case from a perspective of both the sides, how a particular document can be interpreted, right? Anything you start, and that happens most of the times, right? You see your client writing a document to the other side on a contract or in reference to a breach, and the way you read when you are sitting with the client versus in 30 seconds, the judge questions you, but look, this is after the dispute arose, right? Then obviously you are writing it in a different context, so you can't read a document in that form or manner because this document has to be read in the context or the time period in which the parties were. So I think when you are looking at the documents as a counsel, you are looking at it, I would not say biased in form of a client, but only from the lens of a client who is giving you those documents. Of course, you learn through the responses and defense pleadings and rejoinders and that what is the case on the other side, but still a lot of that doesn't come out in the documents the way when you sit as a judge. And I think, I'm sure Mr. Dhond and everyone here would, how much you prepare when you go in front of a judge. The question that judge asks is always something completely different than what you had obviously prepared, right? There will be always one or two questions that you have to say, okay, I'll come back, or I need to look at it. There is something, and you look around and get some help from the assisting counsels and things like that. So I think that instinct never comes when you are just doing a counsel job, right? I think when you are sitting on that chair, as we call it, to adjudicate and give, of course, arbitration is not justice based in that sense. It's not discretionary. It is contractual. Maybe it's a bad contractual bargain. You don't possibly give in reliefs based on discretion in that sense. You are restricted by the contract the way it reads. But still you have that latitude in that sense to look at things from both angles and see how to interpret those documents. So I think that definitely helps when you are preparing a case otherwise, and vice versa, right? I think when you are acting as a counsel, when you go on to the other side, you exactly know why some counsel is putting a case in a particular manner by interpreting certain things in which form and manner. So I think in my view it works both ways. You have to. Yeah, no. You want to? No, okay. So I think it works both ways, and I think it works the other way more, because when you act as an arbitrator or a judge and you come back on the other side, I think you come back with much more understanding as to how both parties look at things, and at least I feel that will obviously bring better sense to your advocacy when you are acting as a counsel.
I mean, we have questions on from counsel to how do you write an award, but Justice Deshmukh has spare time to be with us for this panel discussion as well. We're really thankful, ma'am, for your thoughts and all. I think we should just continue with few more questions, some more time, and then I'm told by Mr. Thakkar that we do have some tea and coffee for all of us there, yes. So before I do that, we've heard about how counsel practice helps as an arbitrator and vice versa. Really, I have a question for you on the drafting of the award itself, right? I mean, we all know that when we get a judgment or an award as a lawyer, we read through every line to find that one thing on which we can successfully challenge that award. And as Justice Deshmukh just mentioned, that she routinely sees all the matters before her for that, right? Do you think that now that you sit as an arbitrator and you are now as a counsel, when you're drafting your award as an arbitrator, you draft it very differently because you know that how a lawyer might look at it to challenge it?
I think the first point I want to make about drafting of awards is that, at least I speak from my own personal experience, is that it takes a disproportionate amount of my time when I draft an award. because you have to marshal the entire record. And unless you have secretarial help of some institution, if you're doing it all alone, it really takes a lot of your time, because your award, you're very conscious of the fact that your award can't be some rambling piece of literature. It has to be a structured award dealing with in a structured way, dealing with the claim, what the claim was, what the defense was, what the evidence was, what your findings on the various issues are. So, at least personally speaking, I find like any draft, and I take a lot of time over the awards, a disproportionate amount of time, I would say, because again, it's a personal choice. One tends to correct and recorrect, but one is always conscious at the back of one's mind as counsel, when you are an arbitrator, that your award is liable to be up before some judge who may take a technical view of it. You may not, maybe it's unconscious, but it's always a thought present in your mind that if I decide this, will I be pulled up, or will some judge say that I did wrong? Many arbitrators I know try to take the safer course by just following some judgment, and say, because you can never go wrong unless, of course, the judgment is completely inapplicable. But many arbitrators, I prefer not to do that, and at least in one or two awards, I have tried in my own little way to say further a little of the law. Now, all that comes because you have had some point argued in court and you felt that the judge was wrong in doing that, or you felt that it was a point not appreciated. So if that is so and it relates to an arbitral point or a contractual point, at least I would try to put it into my award, which is why experience as a counsel sometimes comes into play when you're drafting the award. But as I started by saying, I find it takes a disproportionate amount of my time. In fact, I have always said, and I've said it to judges in court, that I admire judges who can just fire off a dictation or give a dictation off the cuff, dealing with some intricate points in court. I would find that difficult to do because I like to sit and rework my drafts. So it's a personal choice. I mean, I can only speak of what I can do.
I mean, many institutions, including MCI, of course, we have a process whereby scrutinize awards. And we also have a checklist for awards. So when we are appointing arbitrators, we do ask them that if they would want to have that broad checklist to make sure that they tee off all of them to see that the award is less susceptible to challenge.
There has to be a red line, because no institution can tell an arbitrator how he should. He can be told how to write the award, but I don't think an institution has any right to tell an arbitrator what his award should be. That you can't cross that red line.
So I think any institution doing it, including MCI, I would say, is purely scrutinizing, not on the merits. Like, I'll give you an example, Freddie. We had a case where one of the arbitrators just said that issue A dealt in a particular manner, appreciated evidence, and this is what the decision is. Issue B, they said, I feel no reason to comment on this. So the only comment a secretariat would send back is that we would appreciate if you could tell us the reasons as to why you're not considering this issue, right? So I think those sort of things, because you do not want an award to get challenged on this sort. Sometimes we've seen that in an ex parte proceeding especially, the procedural history is not recorded very well. And when that award is before a court, you would not know if a party has been approached well enough when the matter has just proceeded on to ex parte. So I think those sort of things is what an institution brings. And now that we're talking about institution, Vyapak, institutional arbitration is growing. It's slow, but it is growing, right? Do you think that crossing the floor, as our topic is for today, looks different in an institutional arbitration in comparison to an ad hoc in terms of how tribunals perceive the council? More so from that angle, I would say.
Tribunals perceive the council.
And the vice versa.
Sure. So I think, first of all, most of the arbitral appointments, right, when you are starting off, would never be party nominated, right? So it would be, parties would generally try and nominate senior counsels or people with long-standing experience or retired judges. And I think, unlike India, there are not many such options available in other countries as well, right? We have like almost 38, 39 Supreme Court judges getting retired over a period of time, and then 30 High Court with maybe, I don't know how many judges would get retired over a period of time, and then the other judges. So the number of options available in India is obviously very high, right? So only time that you get a chance to get appointed as an arbitrator is either institutions appoint you or of course courts appoint you under section 11 if you are a regularly practicing advocate in that particular court. Otherwise, how would even a judge know how good or bad you as a lawyer would be as an arbitrator? So it's very, in my view, getting appointments is obviously a big issue when it comes to the first appointments and appointments when you are young as a lawyer. But of course, I think if you are appointed by a judge and you are doing an arbitration, obviously the councils and the parties would behave in a particular way, right? Because one, while it is an ad hoc arbitration, but still it is an court appointed arbitration, and ultimately at some point in time it would come under the larger scheme of the court process. When it is appointed by an institution, obviously people look at it that, okay, this is like a private body which is appointing some arbitrator. It's like a service institution rather than a judicial or a quasi-judicial institution who is appointing an arbitrator. So obviously it comes in more category of service institution, right, rather than a judicial institution. And if you are a party nominated arbitrator, right, then obviously the expectation is completely different because then you are expected of to, in a way, rightly, wrongly, directly, indirectly, at least go in a direction of the party that you are getting nominated, which obviously is not the case. So obviously councils look at you very differently depending upon what forum you are getting appointed with, right? If you are appointed in a section 11, as I think Freddie was saying, where judges appoint you, obviously you are looked at that, okay, there is someone who is credible in that sense for a high court to appoint you. Institution obviously comes next, and then party appointed comes next. So I think that doesn't mean that your role is different or your approach is different, but councils do tend to look at you differently because institutions don't come under that category of quasi-judicial authority. I think that is another argument which Justice Deshmukh was making, right? That ultimately you need to look at this as a parallel system rather than an alternate system, because unless you are able to get through this, of course you need the support. Nobody is taking away the support of section 9 or 27 or 34 and of course the execution which comes through the court support system. There is nothing which can happen without the authority of law. But I think at the end of the day you need something which also takes away things from court which otherwise court can use the time for doing something more relevant for which courts were originally meant for. So I think that's the difference I see depending upon who appoints you.
I think it's a very valid point, because we have seen in a case that it was a 3-member tribunal. While the parties nominated the 2 arbitrators, the presiding was to be appointed by MCIA. And when we appointed the arbitrator, one of the nominee arbitrator called and said, though I'm not aware who this presiding arbitrator is, but is his practice more than my practice? And we were like, okay, I don't think that's a qualification which the parties really wanted to have. And we did, of course, go ahead and appointed the arbitrators, and the MCI Council did. But you're right that these sort of questions do come up. And I think today most of you in this room are here because you're either looking at being an arbitration counsel or maybe looking at that shift as an arbitrator. And one thing that we all get spoken about is that why is it always the usual suspects who get arbitrator appointments, right? Is it a coterie which exists out there, like you scratch my back, I scratch your back? And is that what it works really, right? So Freddie, let me get you in here and ask you this, that there's always this debate of arbitrator empanelment, and there is a huge list of arbitrators who are appointed. I will not name institutions, but there are institutions who have 10,000 arbitrators on their panel. But is it the usual suspects who get this arbitrator, right? But when institutions come in the picture and crossing the line, do you think there is a new pool of arbitrators which get created, or is it again just a farce? And I will use a Hindi colloquial here, jo dikhta hai wo bikta hai. So is it still that we are facing that problem, or do you see a shift there?
Look, I think when it comes to appointment of arbitrators, those who have been in the profession, either as judges or as counsel, or as advocates or solicitors, for example, who have been in the profession for a certain number of years, have gained experience, I think will always be preferred as arbitrators. You may call it a closed club, but it's a closed club as long as it's of competent people, as long as it's of people who know their job, as long as it's of people who are certain discipline. I mean, I know there are black sheep in every profession. So you may get someone who doesn't abide by all these good considerations. But I think senior counsel, retired judges will always be preferred because confidence in them may perhaps be greater. A mid-level counsel will take a little time to establish himself. And which is where your institutions, I think, in cricket, in the IPL, you have research scouts or resource scouts. They go to various matches and they see who's playing well. How was Suryavanshi discovered? Because Zubin Bharucha went somewhere and found him playing well. Why can't institutions have that sort of thing? You send somebody to the arbitration court. If somebody is arguing well, you go around and ask whether somebody has a good reputation or not. And that's the way you'll probably get a whole bunch of new persons from the field who can be appointed as arbitrators, and in course of time replace this, what you might call the old man's club or the ex-judges club or the senior counsel's club or whatever nomenclature you want to give it. So that may be an avenue. You can have, institutions have the advantage of having, say, a wider a policy where they can have a wider gender choice. Many ladies can be appointed as arbitrators and they would do a very good job. For a young person, I mean, I see many youngsters here, I'm sure many of them are hopeful of one day being appointed arbitrators. But for a young person, I think to break into this, as Justice Deshmukh said, patience, because it can never happen overnight. I mean, I have a personal example of a young daughter who's an advocate in Zurich and trying to break into the arbitration circuit. And she often tells me, Daddy, how do I get appointed as an arbitrator? And I have no answer. I mean, I said, one of the avenues is if you become a secretary, an arbitral secretary. You're a secretary to an arbitration. You've done a secretary's job for say 10 arbitrations. You get known in the field. And that's another avenue by which a young, relatively unknown person can step into arbitrators as a field. I mean, I know we've been discussing as to whether it's right for counsel to act both as arbitrators, and I remember many years ago when Mr. Ashok Modi, one of our most remarkable seniors who was also a former judge of our court, and Ashok Bhai had once, I used to appear in a lot of arbitrations in those days, and Ashok Bhai had once asked me, he said, Freddie, do you think that I'm doing right by being both an arbitrator in some matters and a counsel in other matters? Because in a multi-arbitral tribunal, he would be an arbitrator with Mr. A and Mr. B. And the next day he would be arguing as counsel before Mr. A and B. So it tends to create, it also has its drawbacks. So it tends to create a sort of a lack of confidence. I mean, nobody would doubt Mr. Modi's competence or his integrity or anything of that sort. But for an unknown person, if that evolved into a system, it would perhaps be sending out the wrong signal. So I think eventually for a young arbitrator, it can only be a matter of patience. For a young person to become an arbitrator, it can only be a matter of tidying it out for a number of years before you get recognized, get known, and I think, as I said, the Section 11 court can play an important role. Institutions can play an important role in that.
Freddy, you've touched a lot of things, and I will bring in Venki just in 1 minute, but for all of you out there who are looking into break into that arbitrator circle, I think probably I have 2 bits from the institution, because we are always looking to appoint new arbitrators. And I'm not saying this, we have published data that 70% of our arbitrator appointments have been first-time arbitrators. And we are doing our bit that we can, but we cannot do it without the support of the right people as well, right? So we encourage that when it's parties nominating, they should also look beyond the usual suspects. Freddie and Venki, no offense here, we do not like to appoint senior advocates. They have just no time for the matter. And my case managers just hated chasing them all the time, right? So there is that crop that we can build, and you rightly said tribunal secretary. Just I'll take 1 more minute. I know I'm the moderator to ask questions, but still just one small comment here. MCI has been doing a tribunal secretary course for the last 5 years, and I can tell you many of those tribunal secretaries have got converted into arbitrator appointments, because they go through a rigorous process of what they can do, how they should draft an award, look at it. CIAB India, which is the Chartered Institute of Arbitrators, a nodal body almost 100 years old, training arbitrators across the globe, is now in India and has been doing courses in India. And I can tell you that people, you've seen a lot of people having a post-nominal called FCIAB. Once you say that you're an FCIAB, there are many arbitral institutions who automatically take you on your panel. When you write to a council and say that this person is an FCIAB, you know that a certain quality exists and they get appointed. So those are some of the points I would say that you need to think about if you're looking at making that transition at some point.
You should just make one thing clear, that all this discussion is in respect of domestic arbitrations.
Absolutely.
International arbitrations are a completely different ballgame.
Absolutely, absolutely. But you also touched about the credibility, right, of the arbitrators. Venki, let me get you in here. Indian courts have been wrongly, rightly, without commenting, has been scrutinizing awards and have got a lot of flack from the international media that are the Indian courts too interventionist. Do you think it is as a result because there is a trust deficit in arbitration? Because we have seen that in the last 10 years, even Freddie spoke about it, Justice Deshmukh said that you have more retired, lesser and less retired judges, more counsel becoming arbitrators. So do you think it's a trust deficit, or do you think it's a reasonable check to have by the court?
I have some pretty strong views on this.
That's the reason the question.
According to me, it is imperative that courts exercise maximum vigilance as far as awards are concerned. I am not a votary of this hands-off approach, and I'll tell you why. Point number 1, you want arbitration to be a substitute for litigation. So you must inspire confidence in a person who would otherwise go to a court that I will get justice, and he or she should not feel that I got a raw deal with an arbitral tribunal and then the hands of a 34 court are bound because possible view, etc., etc. This is all very nice on paper. To a person who is a victim of injustice, it puts that person off and it generally discredits the system. So according to me, first, I am of the view that you should have as robust an interference as possible. Point number 2, look at the accountability of arbitrators. If I am a judge and I pass an order which is wrong or which is considered objectionable, I am answerable to a higher court. My career is on the line. If I am a district court and I pass a stupid order, the High Court is going to look at it, it's going to affect my promotion. If I am an arbitrator and I pass a silly order and it's not reviewed under 34, then there is no accountability. So if you want arbitration to be an acceptable substitute, you must have robust interference. You can't have this possible view business. So therefore what do judges do, and this is what we see day in and day out. If you ask me, very, very few judges look at an award from the lens of this possible, impossible view. They look at the award for what it says. They form a view. Does it disturb my conscience or does it not disturb my conscience? If it disturbs my conscience, most judges are clever enough to slot it into whatever, pigeonholes you make it. So therefore, you call it by whatever nomenclature, day in and day out. As a practical expediency, judges are reviewing awards on the merits no matter what tests you lay down. So I am saying if you reduce intervention or the scope for judicial intervention or interference even less, ultimately arbitration as a mechanism or as a machinery is going to get increasingly the access or the recourse to it in cases where you have an option. People are going to hesitate going into it. So and you already have a lot of people, particularly public sector, governments, etc., who are saying that, look, we as it is feel that arbitrations are giving outcomes which are unfair to us. So you have to give a full-fledged recourse, at least as Freddie said, one court of appeal where it is assessed as a regular decision, because otherwise, why should somebody go to arbitration if ultimately he or she is at the receiving end of some award and then is told, sorry, it's possible we won't. So I have very, very strong views about it.
I just so wish that Justice Deshmukh was here while you were giving this, because in the morning when we met, she said exactly the statement, and I will repeat. If you chose arbitration, live or die with it. So I agree with you that if you have chosen arbitration while you don't have review, maybe you should have it. That's something to be considered for another session probably.
No, but what I am trying to say is that if you say live or die with it, next time somebody is not going to choose arbitration. That's the...
Yeah, I think in my view, your point is, in sense that it is definitely an issue where currently the way the awards are being written or which awards are coming for challenges obviously go beyond a particular level of expectation, right? It's basically, it is not as expected as it should have been. I think in my view, the solution is, yes, we need awards which go less for scrutiny rather than increase the scrutiny so that we don't increase or make the arbitration process more robust. So I think we have two options. I don't disagree with your point that today the awards are such that it requires one level of full scrutiny. Now question is whether our efforts should be in the nature where the arbitration system becomes even more robust, that it doesn't require one level of full scrutiny, or we straight away accept it that arbitration will always be of that nature and therefore better to have one level of scrutiny rather than work around to make the arbitration process even more stronger. I think the debate obviously is that if arbitration is not producing the right kind of awards, it has to be taken care of, and it's, again, I don't think we are different from any other jurisdiction. Most of the jurisdiction, there are many, many awards which get set aside. So it's not like setting aside an award is some kind of a bad thing to do. Question is, how do we reduce the number of awards which, one, come for challenges, and two, which are susceptible to such scrutiny that it should be set aside. I think possibly the effort, if it has been put on the other side, today what choice we have? We have courts with obviously the number of cases and number of things that we know in terms of the efficiencies and the limitations that courts have. Obviously we can increase it and make it better. Here is a option where at least parties who wants to choose a different medium to resolve their disputes, under law, this is not an under the tree panchayat and not susceptible to any legal scrutiny. Of course, this is under the law. Question is whether to make sure that the kind of arbitrations and the kind of arbitrators that we produce are good enough to decrease the level of scrutiny or increase the level of scrutiny. I think that's the way I look at it. Sorry, we are...
His organization will, because she will have a, if I can call it, a dossier on the capability of her arbitrators. I mean, so a whole lot of people who otherwise deliver awards which get the whole process of arbitration, give it a bad name, will not be on that list. So there's a full due diligence done. Secondly, these organizations are constantly monitoring awards. What is the response? How many awards are set aside? So then you have a filtration mechanism where you have only the pick of the lot as arbitrators. Then they will make less and less mistakes. They will be more and more confidence building. Then that will automatically, the more judges see more awards which are sort of well written, the less the scope for interference.
Absolutely.
But that is something which has to be, the confidence has to be built from within. Not because, I mean, you must have arbitrators. Otherwise, look at what is happening. You have a retired Supreme Court judge today as an arbitrator. Till now, he sits 142, does what he wants. He's not accountable to anybody. And then you have a situation, he or she becomes an arbitrator. It takes a huge amount of time to suddenly realize that, look, I am no longer what I was. But if you are like an institutional arbitration who's been appointed from the age of, say, 40, 45, and you have been doing this for a long time, these problems will not happen. So I think accountability has to be there, and
100%.
play a very important role.
In fact, we have a feedback system as well, which the arbitrators may not know, that before they pass the award, the parties have to give a feedback on the arbitrator, which is taken up very seriously by the institution. Anyways, that's, I think we have a lot to which we have discussed, and we can continue to do it. I think one thing that we have for sure learned today is that being a good counsel aids in being a good arbitrator and vice versa. We have just a couple of minutes before Mr. Thakkar will tell me that no more Nidhi. Any questions from the audience, because you don't get them to answer questions without billing usually. Three questions.
My question is, when the client is coming to the court, he has two options. He can go either civil route. Civil route, it is available up to the Supreme Court. But there is a risk factor in the arbitration. He go to the first appeal and second appeal, whether the writ jurisdiction is available or not. But in civil side, he can go to the up to Supreme Court. In arbitration, I hope you get the proper answer. Writ jurisdiction is available in the after first appeal and second appeal.
No, of course not.
No, it's not. Writ jurisdiction, yes.
I'm sorry, your question is writ jurisdiction available?
Available after first appeal and second appeal.
It is not.
Not.
It is not. You can't challenge an award in writ jurisdiction. You can only do it under section 34. So your recourse is only as per the statutory remedies which are available. And the writ court has no jurisdiction to entertain a application to set aside an award or to interfere with an arbitration proceeding.
Thanks.
You had a question.
That now is settled.
Excuse me, do you have a system to train the arbitrator? Do you have a system to train an arbitrator in which you will use the principles of audio alteram partem, and you will pass such judgments which will be sustained, and it will, the whole system of the arbitration will be fruitful in India, because it has been challenged in the international media, because we are a very litigating country, and always one party is not going to get satisfied.
No, we do, like I said, we do have a CIR who trains arbitrators of how do you conduct arbitration. So that system does exist. Happy to take that question offline to see what all sorts of courses exist.
Hi, so my question is to either of the panelists who've been an arbitrator and a counsel like me. Now, as a counsel, when you're drafting written submissions, you are in a sense forceful in the submission you want to make, where you sort of give the justified reasoning as to why your submission has to be accepted by the court. Now, when you wear a hat of an arbitrator and when you are passing an award, naturally you are considering both sides, etc. So, what is the distinction in the reasonings as to the tenor of your language you use in the reasonings to answer an issue? How do you distinguish that between your
your hat as a counsel when you are drafting submissions, when you are much more forceful and sort of insistent on the court accepting your submission as opposed to being detached as an arbitrator in your reasonings?
So, I think what you have to do is you have to be far more muted in the manner in which you express your opinion, because otherwise in a 34 you should not send a signal that you have some proclivity one way or the other. Second, I think most arbitrators who have been arbitrators for a considerable period of time bring inherent to their job, they bring an element of detachment, which we as practicing lawyers don't have, because we are in the thick of things, we identify with what we are arguing. Arbitrators have mastered the art of detachment. When you have sort of got that detachment in, I think the language automatically flows, because if you are detached, you are not going to be in that sense that sharp in what you are saying, unless you feel that there is a need for some criticism or being caustic. Otherwise, I think if you have that level of detachment, then the language will automatically sort of follow the level of detachment.
Just 2 minutes. Having said that, I think as an arbitrator, like a counsel, if you have made up your mind that party A is the right party and that the proposition advanced by party A is something you should accept, I see no reason why an arbitrator can't forcefully put forth all the propositions, everything in support of that as forcefully as he would have put in a written submission of his own if he was canvassing one party's point of view. Of course, as Venki says, you have to be balanced, but once you have convinced yourself that the propositions at party A, you're going to accept those propositions, then I think I don't see anything wrong in an arbitrator then putting forth as forcefully as he can in whatever language he wants, his acceptance of those propositions. I mean, I don't see there's the need for being diffident about that.
I have a
question.
to take permission of Mr. Thakur to allow another question, please.
I have a question with Nitish Sachdeva, wherein the young MCI membership, since you have on your website, so can you be brief, put a detail something about that? And is there any charge to be paid and any internship opportunity?
Yes, I mean, we have a platform for young lawyers because we have a motto, catch them young, train them young. So lawyers below the age of 40 can sort of become a member of this network, which is called as the Young MCIA. It is a paid membership because we do encourage only very serious people who have an interest in this to be a part of it. We do events for them, training sessions for them. There are also internship opportunities, and very recently we also had, yes, and very recently we had an opportunity for them to participate in an event as well and to speak. If you want more details, I'll point you to the right person, who's Anirudh Wright sitting here, who is on the steering committee of the Young MCIA. And I think Anirudh will be able to help you and answer those questions a lot more since he's on the steering committee.
Yeah, thank you so much.
Thank you so much. I must thank Naushad and Nitin this year, but I have to do my duty of thanking the Bombay Bar for putting this event together and for everybody to be here. Thank you, and over to you, Naushad.
Thank you so much. I'm sure you'll all agree that it was an extremely candid and insightful session where all the panelists in that sense gave an idea about, I mean, and it's interesting to see, you know, when two panelists also might have a slightly differing view on the same topic. But that's what makes this so interesting. So thank you again to all the panelists for taking time out from their extremely busy schedules for coming here and sharing with this. I'm sure that the one takeaway that all of you all, especially all the young lawyers, is that please do take up arbitrations as an arbitrator. And according to me, if you are trained properly, once there is a confidence in the decision-making process and in the quality of the decision, courts automatically then will start probably taking a more hands-off approach. What happens today is that the awards that sometimes the judges see, some are well-written, some are well-reasoned, some completely aren't. And therefore, hence, as Mr. Dhon said, there is a need at the end of the day for courts to look into each award and see, has the law been correctly applied to the facts? Even today, as all our courts basically, in that sense, on quality and quantity of evidence, have a hands-off approach. But whether that appreciation has been correctly legally applied is something that the courts look at. And that's something that all as young arbitrators, if you all are keen on being arbitrators, understand how the law applies to the facts and make sure that that is correct in the awards, and then the awards really do in that sense become unassailable. But again, thank you everyone for joining us today. Thanks again to everyone, and special thanks to Mr. Divitri for stepping in as the 12th man, but he always is the opener. So thank you, and please do join us for some tea and snacks.